I thought I would talk about three things briefly. One, what the decision means in terms of what the court actually decided and what it didn't decide. The rationale for the majority decision, which I don't think has been fairly, at least in the coverage I've seen so far, explained. I think it's much more modest and decides much less than people think. And third, a few comments about the dissent. First, why, from my perspective, this is what I would call a modest decision by the court. One, it did not decide the city of Bernie issue. The parties had litigated that issue extensively. The court actually used the McCulloch standard, which was the standard that the government had asked the court to use. Two, it did not decide the constitutionality of Section 5, despite the urging of Justice Thomas, who in both Northwest Austin and in this case had wanted the court to reach the issue. Three, it did not actually decide all issues with regard to the coverage formula. It only decided the formula was not rational in theory. It did not even reach whether the formula is rational in practice. And fourth, by doing so, it gave Congress the opportunity to revisit it. So with respect to the majority decision itself, I think it's important to begin with what Kaiserback actually says. Kaiserback says the coverage formula must be rational in theory and in practice. The decision goes on to explain why the formula is irrational in theory. And I think that conclusion is inescapable for two reasons. One, it's predicated on voting data from generations ago. And two, there's an utter mismatch between the problem Congress was trying to solve, what it called second-generation barriers, and the triggers for coverage, which were first-generation barriers, tester devices, which have now been permanently banned for years. Throughout the litigation, we contested that the court only needed to reach the theory question, i.e., the formula on its own terms, not with regard to the record. The record goes to whether it's rational in practice. It only needed to reach whether the formula by its own terms was rational in theory, which was crucial to the Kaiserback decision. No more needed to be decided, and the court agreed. And I would encourage people to look at the briefing in the case and the decisions below and the Supreme Court dissent. No party of this case has ever offered a theoretical defense of this formula. They've explained why the court should not follow Kaiserback when it said it had to be rational in theory. They explained why it was rational in practice. They defended what I would call the anti-theory of reverse engineering. And they gave explanation for why the court shouldn't worry about that problem. But no one has offered a defense of it as rational in theory, and I would look forward to hearing one today if there is one. With regard to the dissent doesn't really address the core holding of the majority. If you were looking for a discussion of why the formula is rational in theory, you would have to turn to page 33 of a 37-page dissent, and the discussion lasts for all of 2 pages. And then it doesn't even address Kaiserback's language of rational in theory. It simply ignores it and moves on to rational in practice. So the dissent takes on why Section 5 is constitutional, why they disagree with the principle of equal sovereignty, which I don't even think was essential to the holding. It goes on to explain why it's rational in practice. And there are arguments on both sides of that. And the litigants in this case know we litigated that issue extensively about the nature of the evidence in the record and so on and so forth. But the court never reached those issues. Second, and my last 2 points, there's been this discussion of Shelby County standing to bring this suit, which I think is important to keep separate from whether the formula is rational in practice. Those are 2 different inquiries. The argument would be that Shelby County's voting problems are so obvious and so pronounced that there's no way it even has standing to challenge the formula. I just don't think that's sustainable. One, it's a formula. It has to be defended as a formula, and anyone who's subject to it has a right to challenge the rationality of the formula itself. If Congress put all the names of the state into a hat and picked out 12, would the person who was picked have no standing to challenge it because a rational formula could have covered them? I don't think that's a fair charge. Second, Shelby County has never had a Section 5 objection since 1965. It had one sub-jurisdiction in the last 10 years have one objection to one annexation, and it had one consent decree in 1990 to an issue with at-large elections. I would ask the people in this room whether they believe that that evidence is sufficient to deny them standing to challenge a formula that subjects them to preclearance till 2031. With regard to Alabama, Alabama did not have a statewide objection for the 16 years preceding reauthorization, and its Section 2 litigation is on par with states like Illinois and New York. So maybe they could be covered under a rational formula, maybe they couldn't, but I don't think it's plausible to say they lack standing to bring the challenge. Last, I thought what was remarkable about the dissent was its unwillingness to live with what Justice Ginsburg and Justice Breyer agreed to in Northwest Austin. They effectively abandoned the decision with a footnote that says agreeing that there are serious constitutional questions isn't the same as deciding them, but I found that somewhat circular. That decision said current burdens, current needs. It said the formula had to be rational. It said there's a principle of equal sovereignty. I think we could have I'd like to have seen more from the dissent as to why they were walking away from that decision.